Okay, so let's set the scene. A bill gets passed, right? It lands on the governor's desk, and then crickets. Days turn into weeks, weeks into months, and still nothing. So what happens then? Can a court actually step in and say, hey, time's up, you have to make a decision? That's really the core question we're digging into today. Can the judiciary literally put the executive branch on a clock? So here's how we're going to tackle this. First, we'll jump right to the end and look at the Supreme Court's final word. Then we're going to rewind a bit and see the constitutional standoff that led to this whole situation. After that, we'll break down the court's reasoning, talk about checks, balances, and limits. And finally, we'll get into the president's very special power that kicked this whole thing off. All right, first up, the court's final word. Let's not beat around the bush. Let's get right to the verdict. What did the Supreme Court's 5-judge Constitution bench ultimately decide? Now, the full opinion from the court is, well, it's dense. It's 111 pages long, carefully mapping out the roles of everyone involved, the governor, the judiciary, the president. But look, if we had to boil all of that down to just one single, absolutely critical takeaway, what would it be? And here it is, plain and simple. The Supreme Court's answer is a big, clear no. The judiciary cannot impose deadlines on the president or governors. Why? Because forcing a deadline would be a massive overreach. It would basically turn judges into timekeepers for a game that belongs to a totally different branch of government. So how did we even get to this point? I mean, this wasn't some theoretical debate in a law school classroom. Nope. This was a real-world constitutional standoff that blew up incredibly fast and went all the way to the president's office. And when I say fast, I mean really fast. It all kicked off in April 2025, when a 2-judge bench actually did impose a 3-month deadline on the Tamil Nadu governor. Right there, you've got a huge constitutional problem. So, just 1 month later, in May, President Draupadi Murmu stepped in. She used a special power, which we'll talk more about later, to ask the Supreme Court's top-tier 5-judge Constitution bench for a final, clear answer. And by November, bam, they delivered a massive 111-page opinion that settled the question once and for all. Okay, so what was the thinking here? What was the actual legal reasoning behind the big bench's decision? Let's break it down. And this really gets to the heart of the matter, doesn't it? It's the big question. If there's no deadline, what's to stop a governor from just waiting forever? Letting a bill die on their desk. This whole problem leads to a really interesting idea called deemed assent. So what is deemed assent? Well, it's basically an automatic pass. The idea is that if a governor or president doesn't act on a bill within a certain time frame, that bill just automatically becomes law. Poof, it's law, no signature needed. So the court had to decide, is this even a thing? Is this concept constitutional? And the court's answer was emphatic, to say the least. Look at the language they used. Antithetical. That's legal speak for completely and totally against. They said the whole idea of deemed assent goes against not just the spirit of the Constitution, but the entire doctrine of separation of powers. Why? Because it would mean a court is essentially signing a bill into law, and that's the executive's job, not the judiciary's. The court also dug into the actual words of the Constitution. You see, the text says the executive should act as soon as possible. So what does that really mean? The court interpreted it as a guideline, not a hard and fast rule. It's more like a suggestion to be prompt, not a legal command for a fixed time. I mean, it makes sense, right? Some bills are super complex and need a lot of review. A one-size-fits-all deadline just wouldn't work. Okay, so this brings up another big question. Does this ruling just give governors a free pass to delay bills forever? The answer is a firm no. And this is where that beautiful, delicate system of checks and balances comes into play. The court wasn't giving anyone unlimited power. It was basically just acting as the referee and clarifying the rules of the game. Let's look at a governor's options, which are laid out under Article 200. They've basically got 3 choices. 1, they can assent to the bill, give it the okay. 2, they can withhold assent, but if they do, they have to give their reasons to the legislature. Or 3, they can refer the bill up to the president for consideration. Now notice what's not on that list? Just sitting on the bill forever. The Constitution clearly expects a decision to be made. And this slide really gets to the limits the judiciary set for itself. The Supreme Court was crystal clear. We can't impose timelines. We can't just invent a concept like deemed assent. And we can't force the president to ask for our opinion every single time a bill is referred. These are powers the court just doesn't have.
But, and this is a huge but, this doesn't mean governors are totally off the hook. They can't just sit on a bill indefinitely. If they do, the court said that a limited judicial review can kick in. So, while a court can't set a deadline, it can step in and direct a governor to make a decision within a reasonable time. It can't tell them what that decision should be, but it can force them to, actually make one and end the stalemate.
Now, remember how we said this whole thing got started? It was because the president used a very special power. So let's zoom in on that and understand what exactly Article 143 is all about.
This is Article 143, and it's called advisory jurisdiction. You can think of it like this. It empowers the President of India to basically call up the Supreme Court and ask for its opinion on any major question of law or fact that's of public importance. It's a way to get a legal temperature check. But, and this is the key part, the opinion the court gives is just that, an opinion. It's not legally binding. And if you look back, this power has been used at some really critical moments in India's constitutional history. We're talking about huge issues like in 1960 with the Barubari Union case on ceding territory to Pakistan, or in 1998 with the Second Judges case, which basically created the collegium system we have today. And famously, in 1993 in the Ram Janmabhoomi case, where the court actually declined to answer. So the 2025 reference on bill assent is just the latest in a long line of historic uses of this power. So, what's the big takeaway from all of this? At its core, this ruling is a really powerful reaffirmation of the separation of powers doctrine, which is a fundamental part of India's constitution. The Supreme Court drew a very clear line in the sand. It's basically saying that each branch of government has its own job to do, and it needs to stay in its own lane. The referee just can't get on the field and start playing the game. But this whole thing leaves us with one final and pretty fascinating question. While the court slammed the door shut on fixed deadlines, it opened up a whole new one with this idea of reasonable time. So, who gets to define what's reasonable? And who decides when a governor's inaction crosses the line from reasonable delay to an unconstitutional act? It seems this ruling, while it settled one major debate, might have just kicked off the next one.